Hi, my name is Mark Malloy, and I'm a lawyer with the law firm of Meissner, Tierney, Fisher, and Nichols in Milwaukee, Wisconsin. I practice primarily in the area of insurance coverage and insurance bad faith litigation. Today I'd like to speak with you about an emerging topic in insurance coverage litigation circles, insurance coverage for cyber loss. This will be the first of several presentations that I'll do in this format. Today we're going to spend a few minutes talking about what cyber loss is and the evolution of claims for cyber loss, from claims under traditional liability policies leading up to the creation of a new coverage that are specifically tailored to cyber loss. It goes without saying that our world is becoming more electronic by the day. Not only are our social interactions moving the way of text message or Twitter, but our work interactions are becoming more electronic, with the pencil and paper all but obsolete, giving way to our phone, our keyboard, or even our tablets. Similarly, in the last 10 years, our retail interactions are greatly changed. Trips to the store are replaced by trips to a website, even for items of everyday living. With each of these changing interactions, the risk of cyber loss and data breach increases. We all read the stories when they happen. 2011, Sony PlayStation is hacked with 102 million records compromised. 2013, Target is hacked, 110 million customer records compromised. 2014, Home Depot has 56 million point-of-sale payment processors compromised. 2014, Sony Pictures is hacked and millions of bytes of internal data, private information to financial information, are leaked. 2015, Anthem is hacked with up to 80 million records compromised. These stories are terrifying, not only for the multi-million-dollar companies that are victims, but also for the mid-sized, the small company that is increasingly relying on electronic means to run their companies in the most cost-efficient way. In my world of insurance coverage litigation, these stories led lawyers, both representing policyholders and representing insurance companies, to one question: are those incidents covered under the typical business liability policy? The answer to that question is not so straightforward. Let's start at the beginning. What is cyber loss, and how is that term defined in the context of insurance coverage? The term and the concept, relatively speaking, are still at their infant stages when we talk about litigation. While so-called cyber policies have been around for several years, even dating back to the late 90s or the Y2K phenomenon, there's a general lack of case law interpreting these policies and the risks as compared to other more traditional insurance coverage topics. Cyber loss is generally defined as any loss that arises out of the use of information technology or electronic equipment. The most well-known type of cyber loss are the examples we just spoke about. A data breach compromising customer information and company information. But there are other types of cyber loss as well. A virus that is injected into a company's server that causes a loss of electronic data and ceases the company's operations for hours, for days, or even longer. The lightning strike or electronic surge that causes loss of data and disruption to operations. With every change interaction that makes us more dependent on computers or more dependent on electronics in general, these risks become more important to insure against. The damages that can be caused by these types of issues are more than you might initially think. The damage that everyone thinks about is the loss of business income because of the downtime caused by the interruption. But what about the reimbursement to customers whose data is breached? What about the attorney's fees expended in defending claims brought by these customers? What about the cost to repair the hardware? What about the cost to replace software and data? What about the administrative expenses associated with these breaches? All of these losses are potentially losses that could be covered by insurance. So you might be thinking, does my traditional general liability policy cover this loss? If it doesn't, why doesn't it? Well, the answer to these questions have evolved over the years and continue to evolve. The majority of cases nationwide follow a traditional view of law and hold that your typical general liability policy does not cover these types of losses. While many courts have looked at this issue and taken different avenues to the same result, the general thought process is very similar and it's very simple. If you open your typical general liability policy and look at the first-party insuring agreement, more than likely you're going to see some variation of the following language. This policy coverage provides coverage for direct physical loss or damage that has occurred to property located at the premises described in the policy. Most courts, typically early courts, and when we talk about early courts, we're talking early to mid-2000s, look at cyber loss and held that loss of electronic data was not recoverable unless you had some associated loss to tangible property. In other words, you're not going to have coverage for loss of data stored on your server unless you can show me that your server, tangible property that you can touch, was scratched, broken, or in some way tangibly damaged. In probably the most famous case on the issue, the Fourth Circuit made the analogy to a combination lock. If you forget the combination of your lock, then the lock becomes useless. But that doesn't mean that the lock has been physically damaged. And if you retrieve or reset the combination, that lock can be used again. The early courts saw no difference when talking about data loss or damage to software. If the hardware hasn't been damaged, then there's no reason you can't reconfigure or retrieve the data and make it operate properly again. Thus, there is no property damage and no loss under the liability policy. Later courts have taken a more progressive view. Loss of use and loss of function was property damage. And those courts, by and large, look to the criminal code, where there are statutes authorizing prosecution for theft of this information. These courts reason that if you're going to charge someone with a crime for taking this information, then it stands to reason that you can call it property damage when it's lost. If you treat it as property criminally, then you should treat it the same way for insurance purposes as well. That progressive view is the minority when we talk about general liability policies. However, that discussion has been somewhat trumped by this introduction of a new insurance product, cyber coverage. Most insurers now offer coverage against loss of electronic data or other cyber loss in some form or another. Many times the loss that the insurer is protecting against is loss occurring by computer fraud. But more recently, insurance terms have become broader and increasingly protect against loss of data or loss of revenue caused by accidental outages, accidental events. This is a rapidly evolving area of the law. The early returns are that courts are looking at these coverages broadly, and they're particularly concerned about affording coverage for the loss that was contemplated by the policyholder when he or she bought that coverage. For instance, some courts have found that the loss of customer data is not excluded by a proprietary information exclusion. Those courts reason that customer data is not quote-unquote proprietary information to the retailer who took out the policy. And the fact is that that is the exact type of loss that the policy was intended to cover against. However, these issues are rapidly evolving. In future videos, I'm going to discuss particular issues related to cyber coverage and cyber loss and how courts are interpreting the language and the scope of these policies. I look forward to discussing these topics with you further. If you have any questions, please feel free to contact me.